Okay, good morning, and thanks for the opportunity to allow me to make an oral submission this morning. My name's Suzanne Levy, and I'm the spokeswoman for Speak Up for Women. Firstly, I would like to acknowledge you as the committee with the role of considering this bill and all the submissions that it's attracted. As a member of the rainbow community, it's been quite challenging to find that in opposing one of the proposed changes to Schedule 23 in the Act, I'm in the same company as people who've written some pretty confronting things in their submissions about the gay, lesbian, bisexual, and gender diverse people. So I'd like to take this opportunity to particularly acknowledge anyone in the committee who's also a member of the rainbow community. I'd also like to point out that no one person or organisation represents the rainbow community, although some purport to. We are not homogenous mass. We're a community just as diverse in background, life experience, belief and values as any other community in New Zealand. Speak Up for Women's submission does not claim to speak for all rainbow people, though it does reflect the views of many that we've spoken to. Speak Up for Women opposes the proposed changes in the bill to remove the reference in the co-option provisions to approximately 50% of the population being female and approximately 50% of the population being male, and replacing it with a reference to genders, sexualities and sexes of the school students and its school community. Currently, we're dealing with a statement of fact that proposed to be replaced with references to beliefs. Approximately 50% of the population are male and 50% female. Even the very small number of people, approximately 0.2%, who are born with congenital differences of sexual development, are all either male or female. In addition, the use of approximately, the existing clause also makes space for people who may not identify as either male or female. This may have not been the intent when the clause was drafted, but nevertheless, it does do that. The proposed reference to gender is reference to a belief system. The idea that every student in a school and every person in a school community has a gender identity is at best a contested one. It is not an undisputed truth. I don't have a gender identity based on cultural norms and regressive and sexist stereotypes. I have a sex, which is female. Beyond that, everything else is simply a matter of personal preference, interest, and expression. The fact that I have short hair and I haven't worn a skirt in 20 years does not make me any less of a woman than one who prefers long hair and dresses. So, in addition, the ministry has not defined what they mean by gender in the bill, leaving boards simply to guess. Boards who actually have better things to do, like trying to get kids to actually attend school and ensuring that when they do, they leave more literate and numerate than when they arrived, or responding to burnt out teachers, or measles outbreaks, or industrial action, or chronic underfunding of support for kids with additional needs, or dealing with kids watching porn in the playground. And yet somehow this has made the ministry's list of things that need priority attention. The ministry's apparent rationale for this change is that the language needs updating and modernising, except this simply doesn't bear up to scrutiny. The Education and Training Act is only 3 years old. The previous Education Act was from 1989, and between 89 and 2020, we saw huge steps in the acceptance of the rainbow community in New Zealand. The Human Rights Act 93 made it illegal to discriminate on the basis of sexual orientation. Civil unions provided for legal recognition of same-sex relationships, and then eventually the legalisation of same-sex marriage. These three momentous things all occurred in the 31 years between the Education Act 1989 and the current Education and Training Act 2020. And yet the ministry saw no need in 2020 for the new Act to update the board co-option and appointment criteria to recognise genders, sexualities and sexes. So what has happened in the last 3 years that means the wording that was perfectly sufficient in 2020 is suddenly out of date and in desperate need of modernising a mere 3 years later? And if it is so important, why are they not considering all the criteria? There are many people who would regard the reference to socio-economic diversity as outdated, given that it appears to be a maybe a Wellington way of insinuating that poor people may not be able to be elected on merit and so may need to be co-opted. The insinuation that members of the rainbow community are not able to be elected on their own merit is as offensive as it is untrue. All throughout New Zealand for many years, members of the rainbow community who want to serve have been elected to school boards. The inference that we need special treatment or recognition is another form of othering us and yet again calling us out as different. When many of us have fought for the right just to be ordinary, to be boring, to be just like everyone else, to have the same rights as everyone else, nothing more, nothing less, to be chosen on merit, not because of a special identity. Finally, the ministry seems to say that this change requires no collection of information or asking of awkward questions. This simply it can't be true. A number of people we spoke to who are current or former board members reflected that in many instances, they simply didn't know the sexualities of their board members or if any had a particular gender identity. Some said that they made assumptions based on things like partners or spouses' names, but on reflection, they didn't actually know. Others mentioned that it wasn't a topic of discussion as they were focused on what they were there for, which was to govern their school well for every student. So how can a board know if there is a gap in that area without asking the question of their current board? And also, how does the government know that there's a gap? How do we know that this is something that's required? And what if the members of their current board don't want to disclose their sexuality or that they have a gender identity? A person in an opposite sex relationship might not want to disclose that they're bisexual. A single parent may see their sexuality as nobody's business. A person grappling with matters of gender identity personally or within their family may not want that to be board information. Outside of Wellington, for many people, this is personal and sensitive information. And to ask people would be as offensive as going around the table to check on people's financial status to see if anyone was sufficiently poor enough had been elected. So in our written submission, we recommended that the current Schedule 23, Section 1 to 4 be left as it is, as it provides boards, it already provides for boards to consider the full range of diversity in making decisions about co-opting or appointing someone. However, as we've listened to and read submissions, Speak Up for Women believe there's another way forward that the committee could also consider and that we also recommend. So this would be to remove all the references currently in the schedule to ethnicity, socio-economic status, sex, and other characteristics, and simply replace it with one clause that reads, for the purposes of subclause 2, it is desirable, as far as reasonably practicable, that every board should reflect the diversity of their students and their community. This change would meet the ministry's stated aim of modernising the language. It addresses the concerns that have been raised through the submissions process, and it future-proofs the Act by preventing future arguments about what groups should have special consideration. Finally, and most importantly, it acknowledges that the school boards of trustees are the people closest to their communities and so best placed to make the decision about co-options and appointments. So thanks for your time. Have you got any questions?
Thank you. We do have time for some questions, so I'll just look to the committee to see. Erica Stanford.
That was a really good submission. Thank you. You made some really valid points that
Thanks.
I hadn't thought about before, actually, which was very helpful. One of the things you mentioned was around the fact that genders is not defined in here. I'm just interested in what kinds of issues you think this will throw up for school boards who are not, or school boards who aren't au fait with what that means, or what will they necessarily do with that?
I don't know. It's part of an overall issue, which is that historically gender and sex, back when, say, the Human Rights Act was written, gender and sex essentially meant the same thing.
Yes.
Yeah. So now when people talk about gender, they're often what they actually mean is gender identity. And the census is a really good example of that. It used the word gender, but the definition they used was clearly of gender identity. So I think there's a huge amount of confusion. And a lot of boards would probably just look at it and go, sex, gender, it's sex. So it wouldn't be, even if you agreed with what you were trying to achieve by this legislation, it wouldn't be achieving it for those people, because I think they would just take it as meaning sex, and they would look around the room and go, oh yeah, we're about right, then,
Yeah, so you think potentially that if this was to stay, there would need to be some form of definition?
Well, personally, I like the use of the term gender identity. If that's what you mean, that's what you should say. Yeah.
Someone else mentioned that too, I think.
Yeah. Otherwise, gender is thought to mean sex by most people.
We have used up all of our time, but I don't believe we have our next submitters. Is that right? That's correct. So Penny, if you want to.
Just that final recommendation, you haven't got it in your written recommendation.
yeah.
It would be really good to have that,
Yeah,
because
could
Yeah, sure. I can flick you.
Just to the clerk.
Yeah,
that would be
absolutely
great, because it seemed like a very sensible.
Yeah, it just broadens it, and I guess it could save time in the future.
Exactly.
If it's in your notes, you could just give a copy of your notes to the clerk, and then he could give that to us if that's
Yeah,
easier.
I might.
Okay.